Your Honor, that concludes our 9 a.m. docket.
I would ask counsel in 124510 to come forward. Whenever you are settled and ready, you may approach the lectern.
May it please the court. Again, I'm James Latta, the Appellate Defender's Office representing Dary Green. And as your honors will recall, this case is a premeditated murder coming straight to this court. This case revolves around a shooting incident at a liquor store where an eyewitness claimed that my client shot the victim. And for my arguments today, I'm going to focus on issue 2, unless, of course, this court has any questions. And I'll probably keep my remarks brief unless this court has any questions on it, which I'm sure once I start talking, this court will have something to say about that. But for issue 2, I'm arguing that premeditated murder is unconstitutionally vague in regard to second-degree murder. And my argument is that there's no objective standard differentiating premeditation between an intentional act. So my whole argument basically comes down to the primary problem, as stated in this court's case in Harris, is that when there's no objective standard, it invites arbitrary enforcement. And because premeditation, because any prosecutor can allege premeditation, because as this court itself has said, circumstantial evidence usually is usually the evidence used to prove premeditation, that in any act in which there's an intentional murder, the prosecutor, for any reason, without an objective standard, can charge first-degree murder. And for that reason—
How does our Stanley decision not resolve this case? I mean, doesn't your argument essentially require us to overturn Stanley?
I don't think this court needs to overturn Stanley. This court could just invalidate first-degree murder. What my argument with Stanley is that even with Stanley, where this court said that we have, now we know for sure that premeditation requires time and reflection. And so my argument is that because the primary evil we're looking at is arbitrary enforcement, that standard is actually not an objective standard, because a prosecutor can still allege in any intentional murder, a prosecutor can allege facts that there was premeditation.
How does that make it not objective?
Because we still have arbitrary enforcement. That, by definition, the Harris case says the primary evil we're looking at is arbitrary enforcement. And so my argument is that as long as we can still have arbitrary enforcement, then by definition, it's not an objective standard. That's
That's just a circular argument, isn't it? You say it's not objective, so we get arbitrary enforcement, and we have arbitrary enforcement, so it's not objective. I don't think that helps us any.
Sure. But that's the way it goes, and that's still the primary evil. I mean, I don't know how we can say that everything's okay when in any case we can still allege.
Well, without mentioning arbitrariness, can you articulate why the standard, the legal standard for premeditation is not?
Because we have nothing differentiating in real life where we have circumstantial evidence. There is not, in any case, we can claim premeditation, just because as a matter of fact.
What can be claimed has nothing to do with what the legal standard is, does it? If the legal standard is what you just described from Stanley and other cases, a period of time, there's a temporal aspect and a mental aspect, a thinking it over beforehand. I mean, I'm just looking for, I'm giving you the opportunity to make your best argument as to why that's not objective.
Sure, and my best argument is, all I have for that argument is that because it still can allege premeditation in any act, there can still be arbitrariness. There's no objective standard in every case. That's my argument for that one.
How would you define premeditation then in a constitutional manner, at least under your argument and theory?
Sure. I don't have a definition for premeditation. I would say that's part of my argument, is that we have to have the legislature define it. And they have to, I mean, we know from the fact alone that they enacted second-degree murder and first-degree murder, that they wanted a difference. And I think they need to give teeth to premeditation where we have a real difference when we have such big disparities in punishment. You know, I mean, this case, for example, I'll say, Dary Green was charged first with second-degree murder. The state had basically all the facts in the affidavit, the same facts that came out of the preliminary hearing. And then they changed it to first-degree murder. So, I mean, I would say that supports that just in any case, you can charge any intentional murder, you can charge first-degree murder. And unless there's any other questions on any other issues, I'll stand on my briefs.
Thank you.
Thank you.
May it please the court, the state of Kansas appears by Deputy District Attorney Caleb Rayler. I will focus my arguments on premeditation. There is an objective standard for premeditation as defined by the statute, and that is that an individual has to have the opportunity to reflect upon the thing they are about to do.
Could you give me, let's just start where counsel left off. Can you give me an example of an intentional murder that isn't premeditated?
Yes, an intentional murder that is not premeditated is one where the individual committing the act had no opportunity to reflect. It is an individual that forms the desire and the intent to kill at the same time that they are committing the murder. For example,
Instantaneous, that's the difference.
that is the difference, Your Honor, and other jurisdictions have found that distinction with their own definition of premeditation. In Tennessee, they actually had their premeditation definition challenged on appeal in 2000, and they found that while first-degree murder requires forethought, second-degree murder only requires a simultaneous awareness of the conduct or result. And that is exactly how we define premeditation. The act has to be reflected of at some moment in time before they do it. It cannot be at the same time. So if somebody is in an argument and doesn't reflect upon what they're about to do and just pulls out a firearm that has a Glock switch on it and starts firing automatically without thinking about what they're about to do, that would be second-degree murder. That would not be premeditated murder because it doesn't have any of the factors that this court has laid out to help establish what premeditation means. Going to the definition of premeditation, though, go back to our canons of construction. We give ordinary words their ordinary meaning. And the Merriam-Webster Dictionary defines premeditation as consideration or planning of an act beforehand to show intent to commit that act. And that is exactly how this court has defined premeditation, is that there has to be some instance of reflection, no matter how small, before they commit the act.
I think our Stanley case, well, I know our Stanley case talks about this exact question in terms of intentional acts that are impulse decisions, as opposed to intentional acts that are reflected upon.
Correct.
That essentially your argument.
That
Are
is
you
essentially-
agreeing with that essentially?
Yes, Justice. I believe that Stanley provides this court with the exact guidance that it needs to make this decision, in that premeditated first-degree murder is constitutional and has been the law of the land in the state of Kansas for over 20 years. There is no reason for this court to depart from our precedent unless there is a good reason to be departing from it when it has been so well established over the course of 20 years. And right now, premeditation is defined by common sense. It is defined by this court. It is defined across several states as just having the opportunity to reflect upon what somebody does, no matter how short. Tennessee defines it that way, Florida defines it that way, Minnesota defines it that way, Arizona defines it that way, Indiana, Iowa, Missouri, Nebraska, North Carolina, Rhode Island, South Dakota, and Washington State all define premeditation in a way that is very similar to ours. And the only constitutional challenge that I could find in preparing for today's argument was the state of Tennessee that went through an analysis that the difference between premeditation and second-degree murder is exactly what was brought before today, that it cannot be a simultaneous act. There has to be some period of reflection.
Again, I'm just trying to imagine, isn't pulling a trigger takes some, it's not a simultaneous, you have to think, I mean, even if it's reflexive, you're still engaging in some brain cognitive thinking about doing it, even if it's quickly. It's a very tough, it's hard to get over that hurdle of what is reflective and takes thought, and what is versus what is reflection.
Yes, it is difficult, and that's why we leave that ultimate fact to a jury to decide if the state has met that burden of that time period to reflect upon the action that occurs. But also, it comes also down to that individual person's experiences in life. An individual who grows up in a neighborhood where there's a lot of violence would probably act more impulsively or irrationally than an individual that grew up in a more well-to-do neighborhood that doesn't have a lot of crime or violence. Our social backgrounds and upbringings bring us to different experiences in life and give us different reactions to different stimuli that we may experience. So an individual that may have grown up in a high crime rate neighborhood who hears a lot of gunshots may be more reactive to the sound or more reactive to pulling a firearm without even thinking about it, because that is their nature and an environment that they grew up in, versus an individual that grew up in a lower crime rate neighborhood who doesn't have those experiences that a higher crime area might have. For example, taking just a broader approach to it, we all go out to lunch somewhere and we walk into the restaurant and we see a big line. And before we even realize it, we have turned and walked out the door because we don't want to wait in line, but we didn't even make that decision. We weren't even aware we made that decision. We just walked out the door because of what we saw. That is the difference between an intentional, between premeditation and a reflective action. You didn't think about leaving that restaurant. You just walked out seeing how long the line was. It's an impulse. It's a visceral reaction to something versus I'm going to chance it and I'm going to sit here and I think I can make it back to work in time, in my time limit, versus just walking out the door. I would stand on the rest of my brief if there are no additional questions. Thank you.
Counsel.
Our remarks brief. In all those examples, you could still at least allege. I mean, when someone walks in a restaurant, the prosecutor still alleged they thought about it before they walked out. That's really my argument. And then the only other thing I'll say is all the states that she cited, they're all wrong. In any premeditation murder, you can still, in any intentional murder, you can still charge premeditation. And unless there's any other questions, that's my argument.
Thank you.
Thank you, Your Honor.
Thank you to both counsel for your arguments this morning. The court will take this case under advisement.